So good evening, everyone. I'm Manvika. On behalf of Naman HR, I welcome you all in today's webinar, which is Demystifying New Wage Code and Social Security Code. Naman HR is a 16 years old HR consulting firm. We are specializing in assessment, L&D, and various other core HR services like PMS, Comp and Ben, organization structuring, amongst many other such core HR services. In our endeavor to contribute towards the compensate needs of our various organizations, we have kept this webinar. Major focus would be to bring more clarity and understanding on the new labor codes. Primarily, in today's webinar, we'll try to create awareness around the new changes which have been introduced under the new labor codes. What is the impact of these new codes on the compensate structure? And to conclude with, what are the anticipated challenges during the implementation of these new codes? So without further ado, I welcome our guest speaker, Ms. Mayuri Raghuvanshi, who's advocate on record with Supreme Court of India. Over to you, Mayuri.
Thank you very much, Naman, and all the brilliant people associated with Naman, including Manvika, for a warm welcome and for inviting me to speak on an important reform in the field of labor laws. Now, if I may just request Manvika if we can just straight away come to the second slide in here so that we can straight away start on the point and I can explain what all we are going to cover here. So I have no hesitation in saying that the issues that we are going to discuss, which is so important that it is something that that covers one of the major discussions even in the Constituent Assembly while the Constitution was being framed. And as we know that the evolution of labor laws or industrial laws as we understand it today is very interestingly linked with our freedom movement, and it is one of the most important facet of our freedom. And it's so much so that if one goes back to a preamble and see that even preamble talks about equality in economic terms as well. And therefore, when you look at labor laws, it's actually a symbol of our freedom, of our democracy, and also of our constitutional values. Now, with this backdrop in mind, when we look at the existing laws on labor laws, they are some of them are really old. So much so that like Industrial Dispute Act is of 1947. And subsequently, when with the interpretation of the courts and the judgments as they came on and came forth to include those judgments and incorporate them into the statutes, so many amendments had taken place in the act. And in this backdrop, therefore, there was a need which was felt to revisit and review these laws. So there was a second National Commission on Labour under the chairmanship of Sri Ravindra Verma that came into existence. And what it did was it says that all the existing laws must be classified now and clubbed into 4 categories. So the first category that they were looking at was industrial code relations. The other category they were looking at was all the laws which dealt with the safety and the working conditions of the workmen, which you can see is in the circle, the second circle that you can see on the screen. And there were other 2 classifications, and these 2 classifications are the one that we are going to deal with in this webinar today. So the third one was on wages, and the other one was on social security. Now, of all, I mean, we have tried to put this on the slide and show to you when each one of these laws were tabled in the parliament and how it came in. But I must point out to you that the Code on Wages was the first one to come on board. And by saying this, I think you can understand that what is the importance of wages. At the end of the day, wages are the most important facet of any employment. And therefore, they were the first one which were tabled. Now, if I may please request for the second slide so that we can straight away, go to the Code on Wages. Yes. So if you look at this slide now, what the Code on Wages has done is it has, if I may put it in a layman's language, and I'll try and use not to be too technical throughout the session. So what it has done is, in a layman's language, it has replaced four existing laws. And what are those four laws? So they are Payment of Wages Act 1936, Minimum Wages Act 1948, Payment of Bonus Act 1965, and the Equal Remuneration Act 1976. Now, I'll just stop here for a moment and I will draw your attention just to the years so you see how old they are and why there was a need now to revisit, because things have changed with the passage of time, and law can never operate in vacuum. Law has to change with changing times, with the changing demands. Now, therefore, what may have been relevant in 36 may not be relevant today in 2021. And therefore, there is a need now to consolidate them and to have a new law. But what is also interesting here is this, that what it does is that instead of four laws now operating in the domain, you have one code. So by doing that, what it has done is it has tried to bring one major change, which is to standardize the application of law across the industries. So rather than looking at, because each of these act, whether it was Payment of Wages Act, Minimum Wages Act, or the Payment of Bonus Act or Equal Remuneration Act, they had their own set of scheme, and they were to be read and interpreted within the framework of the scheme, within the framework of each of the statute. Now, all that has been rationalized or standardized, and everything has been put in one place under one code. So the first thing that this act has done, code has done, is this: it has simplified the four laws, amalgamated all these four laws and brought them under one roof, and that is the Wages Code 2019. The other thing that what it has done is that it has expanded the scope. So while it has replaced it, at the same time, it has also tried to extend the applicability of this code. So, for example, earlier the code would have each one of these act prescribed, a threshold level, and as we'll come across, I will point out couple of sections to you, and it will become clear that how the coverage has been expanded. Then if you look at this, the one of the major things it has done is now you have one definition of wage which applies to all these four aspects, whether it is the Payment of Wages Act, the concept or the principle in theory that was applicable to Payment of Wages Act or Minimum Wages Act, or the Payment of Bonus Act or Equal Remuneration. For each one of these acts, one had to understand what is meant by wages. So what this act has done is it has actually defined the wages, and by defining the wages in the code, they have sort of given you a standard definition of wage that would be applicable to all these four concepts. So in a way, it is not wrong to say that it is a historic bill, historic statute. It is not incorrect to say that it is one major reform in labor law which we are seeing in the post-independent India. May I please request for the next slide now? Yes. So one, continuing from what we were discussing. So as it has changed, replaced these four acts, but the principles, broad principles, have been continued. The obsolete interpretations of laws have been replaced. So for example, now they have a mechanism. They talk about, the authorities. They've established certain authorities. But at the same time, the idea of this code is this, that they want to hold people accountable for not following the law. Now, if one out of there are several other codes that had come, but as I said, that code on wages was the first one to come. The idea here of having the code on wages first is actually shows the importance. And in fact, anybody who's well versed with any such who has in past dealt with these reforms, and even people who have been working on policy issues, they know that whenever one is looking for reforms or undertaking a study to reform, the primary component always relates to pay. So wages is something which is foremost and very important component of any labor reform. And this code actually addresses that. So if I have to say that what in one line, that what it really does is it puts a system in process and tries to streamline the existing processes. So one, it is trying to simplify the existing process and to streamline the various processes which were already in place in under one head, so that there is a standardization. And by this, they are what the legislative intent is basically to reduce the chances of misinterpretations, chances of lessening the number of disputes with due course of time, because there is less ambiguity on application. So these are some of the novel ideas with which they are looking forward to go ahead with the implementation of this code. Now, if I may please request for the next slide. Yes. So the crux here, as I was saying, is that they have what the most important aspect here is this, that they have described wages. Now, by wages, they have actually, because we know that when the salaries are being paid, they could be paid in number of ways. So sometimes, it's called a salary, sometimes it's called a retainership, sometimes it's called remuneration. It could be called under different, it could be named differently. But at all point of time, what it does, it has clarified that what wages mean. And they have defined what wages would include, and they have defined what wages would not include. And as a result of which, the impact it's going to have on the employees is this, that it is going to affect the take-home salaries of the employees, the wages. And interestingly, what it does is that for the first time, it also takes into account the fact, like, for example, one change here is this, that your basic salary can't be less than, has to be at least 50% of your gross salary. So as we know that a salary component, or CTC as we understand it in common parlance, suppose let's say it is 1,000 rupees for a person. Now it may have two components which primarily consist of the basic salary and could also include other DA, and if you have a retainership allowance or something, and the other component was something paid by way of allowances. Now it is commonly known that what was happening was this, that out of this 1,000 rupees, what would happen was that 400, let's say, would have been the basic salary and 600 would have been the allowances. Now, what this act does is that it actually tells you that if you are saying that this is the wage, because understanding the concept of wage will have an effect also with respect to the other act. Like when we come to the Social Security Code and we come to this concept of Provident Fund, where as of now the employer is supposed to, the contribution is fixed at 12% rate, and employer is also expected to make an equal contribution. So there your contribution would depend upon what your basic salary is. So therefore by defining what your basic salary is, what the basic wage is, they have sort of brought a change in this whole concept of what would be the takeaway salary. So what the PF deduction would be, how the basic salary would be computed, how other tax would come. Now all these things have undergone a sea change. So if you're going to ask me that what is that one section which is most important in this entire code, I will say it is the definition of wages, because that is where for the first time the legislator has not just informed us that what is included, but also what is excluded. So now when you say that these are the wages payable to an employee, you have to be very clear that this is what is included and this is what is not included. And in long term, by defining what is the wages, they have also made an attempt to bring them at par with the living, because they are now talking about the concept of cost of living. They are now talking about the concept of linking this wages with the other aspects of economy. So the noble idea, as we say, the idealistic intent behind this code seems to be this, that they want the code, they want the wages to be defined, and they also want it, the in-hand salary that comes, to have certain components and also to be computed keeping in mind certain components. But having said that, if I may please request for the next slide once again. But having said that, before we really go and dig deep into this concept of wages, I still want to point out that under the existing law, we do have this concept of minimum wages. Now, even under the new code, we do have this concept where it is mandatory for an employer not to pay wages less than the minimum wages. So principally, there is no difference. And also, what is not different here is this, that even now under the new code, the right to fix what minimum wages would be still vests with the central government. Perhaps the mechanism has been, changed a bit. So where, you would earlier have things in the Gazette notification, now the state governments also have a power, and they have prescribed guidelines that these are the things you will take into account while fixing the minimum wages. But broadly speaking, earlier also the central government had the right to fix the wages. Even now, the central government retains that right to fix what minimum wages would be. But nevertheless, the reform is something which is which is something we can't undermine or look down upon, because if you look at the definition of wages as it is given under the Act, it's wide, it's huge, and very, very much in detail. So what it includes, it's very interesting. It includes three things. Now, most of the employments, they have two components with them, which is the basic pay and the dearness allowance. And there are some employments where they do have a concept of retaining allowance. So what the first part of the definition says under the code is this, that wages will include basic pay, it will include dearness allowance, it will also include retaining allowance if it is applicable to you. And then it goes on with a list of things which are not included. So what is not included is a statutory bonus. Suppose under the law existing at the time being in force, an employee is entitled to a bonus as per the law or as per the Act, rules, or any statute, guidelines framed, or any scheme framed by the government or the employer. Now that statutory bonus will not be part of the wages. So when you calculate wages payable to an employee, you are not going to include bonus which is payable under the law. So statutory bonuses are excluded. Then the second component which is excluded is the value of house accommodation, supply of light, water, medical attendance, or other amenity or of any service excluded for computation of wages by an order of the appropriate government. So there are two things that we'll have to take into account. As if I am an employer and I'm calculating wages, I will take into account two things. So one, the value of house accommodation, supply of light, water, medical attendance, or amenities. And this assumes all the more importance, because when you look at the definition of wages in the Social Security Code, which we are going to cover in the next part of our webinar, we will see that these things then assumes all the more paramount importance, because these are actually related to the concept of social security also. Now, these things are excluded. Plus, what is also excluded is this, that suppose tomorrow the government issues a notification saying that apart from the house accommodation, the value of house accommodation, A, B, C, D, these are also the things which will not form part of the base of your wages. Then as an employer, we will have to take care and we will have to make sure that those components are not included in the wages. May I please request for the next slide now? Again, employer contribution to any pension or provident fund. Now, even under the existing law, the provident there is an employee who contributes to the provident fund, and there is also a employer's contribution to that corpus. Now, that system will still exist and will continue to exist, but that employer's contribution, just as it was in the present regime, not part of the wages, it is not part of it is not something which is part of your basic salary. Similarly, even under the wages, under the definition of wages, the employer contribution to the provident fund will not constitute the wages. And what is to be highlighted here is the reference is only to employer's contribution, not to the employee's contribution. Then conveyance allowance. If you are paid any conveyance allowance, that again will not part of your wages. Sums paid to employee to defray special expenses on him by nature of his employment. So sometimes the nature of employment is such that a person becomes entitled to a special allowance. Out. House rent allowance. So HRA is not part of the wages. Remuneration payable under award or settlement between the parties or order of the court or tribunal. Clear. It's not something, it is something that we have been following it. So whenever, if you pay certain amount to a person because of a settlement or because of an award or because of there is an order by the labor court or by the industrial tribunal, even in those cases. Overtime allowances. Now this is very interesting because this goes on to define that what would constitute an overtime. And very clearly the wages, the definition of wages does not include the overtime allowance. So suppose if a person is paid, let's say 100 rupees, his otherwise his wage is 400 rupees a month, and by way of an overtime, the employer pays him 100 rupees more. So he takes home a total of 500 that month. Even then, that 500 would not constitute wages. The wages would continue to be 400. And that 500, even though you have paid him because of the overtime, because of it's not an allowance, it's not an it'll clearly be excluded from the definition of wages. And this will of course have an impact on the other statutory provisions, like how the tax is going to be calculated or how the provident employer's contribution to the provident fund will be calculated. So all these things will have an impact on what the actual wages will include or not include. Gratuity payments. Again, it's not a landmark shift. Gratuity payments are not included. The last thing is pretty interesting here. It says retrenchment compensation or retirement benefits payable to employee or any ex gratia payment made to an employee on termination of its employment. Now we all know that termination of employment is something, termination upon employment is something which is not something that employers or industries across have been following uniformly. Each one of them, and sometimes, the compensation, the retrenchment compensation is something which is either paid under a policy or it may be paid, under the orders of the court. What this act does is that it does talk about, forming a trust where an employer is expected, to deposit 15 days wages in that corpus, towards each one per retrenched employee. Because the idea is now to give retrenchment compensation whenever such an employee is terminated. Now, that contribution or that payment which is made, that clearly is not part of the wages. So it means that when you are looking at wages, one has to be very clear that there are other components that an employer may pay to an employee during the course of employment, which could be by way of a statutory bonus, could be by way of a conveyance allowance, overtime, gratuity payment, retirement benefits. Now, these things will not constitute his wages. May I please request, therefore, for the next slide now. Now, if you look at it in this backdrop, we'll come again, to this concept of wages. But if you, in this backdrop, when you look at the code, you see there are two more provisions that they have sort of incorporated or which were already in existence. So for example, section 3 of this code, it deals with the concept which is taken from the Equal Remuneration Act that it seeks to replace. Now what equal remuneration does is, the act which was in place, it basically talked about that the entitlement of workers to a equal remuneration irrespective of their gender or other things, because we know that historically there have been a provision, especially with labor laws, because they said that women laborers were not able to put in as much work as a male laborer would do, and therefore their salaries, historically their wages were always lesser than the male counterparts. Now, this is something, that was found unconstitutional, and of course we have the higher goals of Article 14, 15, and 19 and 16 now before us. But even then, the Equal Remuneration Act, which has been replaced here, also echoed that same sentiment. Now, what Section 3 does is, it does the same thing, but interestingly here, very specifically, they are referring to gender. So Section 3 refers to gender equality, and basically what they mean to say is that you are not going to be paid, your wages will not be unequal on account of your gender. And interestingly, it is now not just about man or woman, it's also about transgenders. So today, Section 3 echoes the sentiments and the laws and the judgments of the Supreme Court on the concept of gender equality. So just as Supreme Court has recognized transgenders as also one of the classes, the Section 3 of this Act not just echoes the sentiment of the Equal Remuneration Act, it also echoes the sentiment as it would exist today and apply today in the society. The other the other highlight that I can point out is Section 9 of the Act. What Section 9 does is that it has proposed this concept of a floor wages. Now, floor wages is something which will be decided by the central government by taking into account the minimum living standards of the worker. So now, here there is a chance for the government to take into account things as they would progress or change with time. So one will have to, when you fix the floor wages, you actually will have to take into account the ground reality and the changed circumstances, the existing circumstances, to understand that what is the minimum standard in which these workers could live. And they will also take into account the geographical area and the skill of the work. So, for example, maybe the living standard or the minimum living standard that is expected in Bihar would be different from what in Gujarat. So you can't apply a straitjacket formula by a gazette notification to all of them. You will take that into account, and then by virtue of Section 9, the state government will then come forward and will propose what is going to be the floor wages. In fact, if I read out the title of Section 9, it says power of central government to fix floor wages. So basically, it empowers central government to fix floor wages, taking into account the minimum living standards of a worker. Now, why it is important? It is important because when you say that I will take into account the minimum living standards, you introduce a concept of dynamism in the whole definition, which means now the definition or the principles are not static, and the power is to take into account the changing circumstances. So the definition itself becomes dynamic. It is not something which is static. The people, the employers and the government can always come forward and say things have changed and now this is the existing reality and this is how we are going to work upon it. So this is one. Whereas, when we were looking at the Minimum Wages Act, or what usually used to happen was that the government would come out with a notification and say that these are the minimum wages, unskilled, skilled, these would be skilled laborers, this would be unskilled laborers, and these are the minimum wages for each of these categories. Sometimes at best they would take into account the geographic locations, that all right, in Delhi this would be the minimum wages, in UP this would be the minimum wages, that's it. But the concept of minimum living standard is something which is very welcoming and it's new. May I please request for the next slide before? Yes. Now, coming back to the other highlights here is this, that what it does is it also tries to, provide a timeline for deciding disputes. So, for example, they have fixed a limitation period for filing claims for minimum wages, equal bonuses or equal remuneration by workers, and it has been enhanced to 3 years against the existing time period that varies from 6 years to 2 years under each of these four statutes. So one is this, that now if I have a complaint, if I have a claim as a worker for minimum wages, I can do that for a period of 3 years. Whereas under each of these statutes, there were different periods which were prescribed. So they've standardized it, put a 3-year cap, increased it to 3 year, which in the earlier regime, the maximum was 2 years. So this is one step that they have done. The other thing that they have done is that the procedure to fix minimum wages is now given under section 8(2) that stipulates procedure, and it becomes every right of the worker thereby that even if he's under the unorganized sector, to have an access to this concept of minimum wages. In fact, as we speak, when one looks at the section 8, and especially section 8(2), it says that every committee appointed by the appropriate government under the clause of subsection 1A shall consist of person representing employers, representing employees, which shall be equal in number as the members specified in clause A, which is employers, and then independent persons. So now they have, when they are talking about the process to fixing minimum wages, it is not just happening unilaterally, but just by virtue of the statute, they have tried to bring all the players, all the representatives, not just employers, but also employees there. Now, earlier, these things were done by the trade unions, and this was all by way of collective bargaining. Now, I would put it like this, that whole concept of collective bargaining has been given a statutory right. Now, it is the statutory right of an employee to be present and participate in this process by virtue of section 8(2). The other highlight that I can share with you is this, that the central or the state government can fix the number of working hours that constitute a normal working day. Now, what a normal working day would be, like section 13, for example, talks about that fixing the hours of work for a normal working day. Now, therefore, as it says, that for each one of us, each industry is different. And this concept of working hour or a working day is something that we say was more pronounced in in provisions like Factories Act, but we did not find these concepts really, there in concepts relating to a Minimum Wages Act or otherwise. But now they have come up with an elaborate process relating to fixing of hours of work of a normal day. And what is very interesting here is this, that they not just say that the government is going to fix it, they also tells us that how they are going to fix it. So for example, and they have also put a ceiling limit. So what they say, for example, is they say that the normal working day will constitute a maximum of 9 hours per day with a maximum spread of over 12 hours, including rest intervals. And then in case of excess to the normal working day, the person becomes entitled to overtime wages, which must be at least twice the normal rate. So now this is one interesting change that has come in, because now you have a ceiling limit on a normal working day, plus you work for more number of hours, you become entitled to an overwage. If what the rate of that wage would be is also now prescribed under section 13, because now it says it has to be double. It has to be twice the normal wages. So if suppose for an hour, I was entitled to 100 rupees, then if I have worked beyond 9 hours, then automatically I will become entitled to, another 200 rupees. And what is interesting is this, that this 200 rupees will now not be included in my definition of wages. So this is one change that has come in. Then the employee's wages may be deducted on the ground of absence from duty, accommodation given by the employer, or say recovery of advances given to the employee. But the deduction even then should not exceed 50% of the employee wages. Now, there are provisions there. So we do have a right, to deduct the salary from when an employee has absented himself from duty. But what this code also does is it puts a cap of 50%. So which means if a person is absent, the deduction, I may make deduction, I may make even, I can even, initiate recoveries, because this is something which does happen, especially in cases which pertains to disciplinary actions. But in those events, when you're looking at, so do not confuse this with penalty. Penalty is different, which will happen under the service rules. But under the code, when we are referring to deductions, it can't be less than 50%. May I please request for the next slide? Yes. So summing it up, here is this, that irrespective of whether you are an organized sector or you are an unorganized sector, you are somebody who is employed through a contractor, or you are a principal employed directly. In all cases, the definition of wage which is payable is one and standard that applies to you. That includes basic pay, dearness allowance, retaining allowance. And if I may request for the next slide, please. And what it excludes is these things that we had just dealt in an earlier slide. So statutory bonuses, value of house accommodations, employer contribution to PF, conveyance allowance, special sum paid, HRA, remuneration paid under an award or settlement, overtime, commission, gratuity, and anything which is paid upon retrenchment or retirement. So when you, broadly speaking, these are some of the things that one will, this is the soul of this entire code here. May I please request for the next slide? Yes. So now, if you will, what actually these changes have done and what impact it has on an organization. So if I may say, the impact it has on an organization is basically three. Number one, basically what this change intends to do is it intends to simplify the process so that the business operations can be smoothened. And as by way of simplification, the biggest example here is this, that earlier you had 4 acts applying to you in this domain. Now you just have one code. So everything flows from one statute down. So that is simplification. Then the definition of employer has been broadened. So now it includes principal employer as well as contractor. As a result of which, the scope of application of this act has now increased. Then by giving a definition of wages which is applicable to all the 4 concepts that were dealt under 4 different statutes earlier, they have brought about a standard application. There is a universalization of laws and application of laws, and of course, with time, we will come to know that how successful we will be in actually implementing it. But as of now, it appears that because we have one common definition of wages, it would apply same when you are looking at the concept of minimum wages, bonuses, or for that matter, you are trying to apply it in case of a concept to a contractor or to a principal employer, which means that whether you are from an organized sector or an unorganized sector, the definition of wages will not differ for you. So with this, may I please request for the next slide? Yes. If I have your permission, I'll very quickly finish the code on social security, which I hope we are able to finish in time, and then we can take on question. Is it okay with everyone?
Yeah, surely. Please.
Thank you. Thank you. So the code on social security is another very interesting reform. it is also part of the law reform and also part of the recommendations which were given by the National Commission on Labour, the second National Commission of Labour under the chairmanship of Sri Ravindra Verma in 2002. And it is one of the components, one of the 4 components that we had dealt with. Now, what this act does is, this code actually simplifies 4 existing legislations. There were 4 acts which were governing this domain, this area, and it has sort of, amalgamated all these 4 existing statutes. Now, what those statutes are, I'll just very quickly read out for you. So the first one was Employees Compensation Act 1923, enacted before the independence, applicable till now. The Employees State Insurance Act 1948. Then Employees Provident Fund and Miscellaneous Provisions Act 1952. So this is also something which was just enacted immediately after our independence. Then Employment Exchanges Compulsory Notification of Vacancies Act 1959. Then Maternity Benefit Act 1961. Payment of Gratuity Act 1972. Cine Workers Welfare Act 1981. Building and Other Construction Workers Welfare Cess Act 1996, and the Unorganized Workers Social Security Act 2008. Now, you can see it covers almost 9 different varieties, but what all these 9 acts were aiming to do was, they were trying to provide social security to the workmen, whether in the organized sector or in the unorganized sector. So what the benefit of this amalgamation are many, like as I said in the Code of Wages, but here with respect to social security, because the number of legislation and the different concepts applicable are much more than what is applicable to a code on wages, it becomes all the more important to have this code now. The reason for this is that now there is no multiplicity of definitions here. So for example, this code on social security also defines wages, which is identical to the definition of wages given under the earlier code, the code on wages to 2019. So in a way, the confusion that we would, oh, the wages are defined under that act like this or under this act like this, now that goes off the window. There is a standard definition of wages which is now applicable across the board. But more importantly, what it does is, see, earlier there was, for example, there was Gratuity Act, there was Maternity Benefit Act, and these acts were independent of each other. But today what has happened is that now by putting everything under one code, it has given power to the state government now to frame schemes flowing to have a lawmaking power from the act. So if I may just give a little backdrop on the legal background here, that how the system would work. See, an act is a law which is passed by the parliament or by, in case of a state legislature pertaining to a particular state. Now, under the act, there are powers which are given now to authorities, which could be sometimes central government or state government or appropriate government, depending upon who that appropriate government is. And those powers are rule-making powers, powers to make rules. Now, rules, basically what they do is that while the act will talk about the larger broad principles and give the broad framework of the regime, the rules are the one that provide muscles to the skeleton. Now, one of the biggest difficulties is that unless and until you have a rule-making power bestowed upon you by the act, which is passed by the parliament, you may not be able to frame or may not be able to effectively provide muscles to that skeleton which has been put in place. So one thing that this code does is that it recognizes this power, and it empowers the state government now to formulate schemes for the benefit of the workmen covering these areas. So, for example, if I can just share with you, may I? So if you look at this slide, what we have tried to tell you is that one, it simplifies And what happens by way of the amalgamation is this, that it facilitates the implementation. Okay, it facilitates the implementation. Also, the use of technology is something, coming up again and again in these statutes, because now, for example, the wages and the benefits which an employee is entitled to can also be paid electronically, can be transferred. Now, this is something, which has been done, keeping in mind that how technology can be of use. Also, we know now that a lot of things are being done online. So by use of technology, it is something which you will find, even the compliances is something which is recognized. And by doing so, they have tried to incorporate the concept of transparency and accountability also. And then they are, so basically they have set up this whole regime trying to make sure that there are compliances. So for example, there is this whole concept, which is provided here, that of registration. So where the employers will have to apply for registration. So they have provided for a system. There is a entire a portion in the act which is given to registration. But at the same time, it as I'm saying, it has sort of widened the coverage. How they have widened the coverage is that now under the act they have not just described what is a fixed term employment. They are also describing who will be gig employees, who will be gig workers. They're trying to bring in the people who were otherwise from the unorganized sector also under one roof, under the same statutes in which they are going to cover people from organized sector. So by doing this, they have sort of enhanced the term. And as we come along, I will show to you that the other thing that they have done is that even with respect to, like, as I said, that one of the acts it seeks to replace is the 1952 Act on EPF, which talks about which deals with the provisions relating to Provident Fund. Now, even there, under the present law, there is a concept where the employers can have their own trust, and we have this concept of exempted trust. But now that has been increased, that only if you're 100 and above. So there are changes which have come in. Now by doing this, what impact it has done is that it has widened the coverage. So which means not just the workers, as I understand. So I would understand my worker and I would give it a very limited definition. But now by defining that this is fixed term employment under Section 234, they have also defined the other forms of workers. Like, for example, they have described the concept of, gig worker, home-based workers. So these are some of the concepts, which were not described earlier, but now they have described it. So while they described that a fixed term employment would mean engagement of an employee on the basis of a written contract for a fixed period, and then they gives up the provided so and so and so and so. They also, in the same breath, defines that a gig worker is a person who performs work or participate in a work arrangement and earns from such activity outside of traditional employer-employee relationship. So just see that how they have, covered, they have, widened the whole canvas of application of law now. If I may please request, very quickly for the next two slides. So I will not, really go there. So if you, as I had said, there were these existing laws. So for example, there was this concept of Provident Fund, now, which says that it would include basic DA, retaining allowance, cash value on food, and exclude these things. Then it says, and there were judgments, to that effect. Then you had employee state insurance, which says that it includes all remuneration paid in cash. Then there was gratuity, which said that now there is a basic salary and earnings allowance. May I please request for the next slide? Then there was this concept of maternity benefit, which says that there would be basic salary, DA, HRA, cash allowances. And then there was an Employee Compensation Act, which has also been replaced by this code and says any privilege or benefit which is capable of being estimated in money. Now, if I may please request for the next slide. Yes. So the first thing what it has done is, it has all these different concepts have now merged, because under section 2 subsection 88 they have defined what wages mean. And they have said that wages mean all remuneration, whether by way of salary, allowances, or otherwise expressed in terms of money or capable of being expressed. And then it goes on to say includes basic pay, dearness allowance, retaining allowance, same as the definition in the wages code. And then does not include, again, the same things: statutory bonus, house accommodation, contribution paid to by the employer, then any, traveling allowances, then some paid special expense by way of special expenses, HRA, money paid by way of settlement or under an award, or overtime, or commission which is payable, or gratuity which is payable, or retrenchment or other retirement. So now what it does is that while we were dealing with different concepts of how what is payable, because that is how you decide and you define the amount which is payable. So for example, for the purposes of gratuity, you are going to calculate the wages or the salary earned in a different manner. But now by standardizing, giving one definition of wage, which is going to apply to all these concepts, they have brought standardized it, and they have brought down one uniform application to all these concepts. So whether it is for the purposes of a maternity benefit, it is for the purposes of insurance, it is for the purposes of gratuity, you will look into the definition of wages as it is now given under the Act. And interestingly, under this code also, the definition of wages is not different from what we had under the wages code. So there is a standard application. Then the other thing what it does is that our idea, the way we were up till now defining the concept of fixed employment. Now that is something that has also undergone a change, because now the code really defines what is a fixed employment and also what would be excluded from the definition of fixed employment. So we may or may not have that liberty which we had earlier to define that, oh, he's my fixed employee, he's not my fixed employee, or whether my nature of employment with him is different. So you will have to go by what is defined in the Act. Then the other thing that it has brought about a change is that, as I said, that it has widened the social security coverage. It has widened it because it has defined and recognized other workers also. It has brought in people from the unorganized sector also within its ambit. Then it has imposed a restriction on maintaining an own PF trust by an establishment. So unlike the older times when the PF trust, you could go and under section 17 or 16 of the 1952 Act, you could really apply for an exemption and have your own trust. Now that has been changed. Now you can only do it if the strength of the employees is 100 or more. You can't do it if it is lesser than that. And then it applies to all establishment with 20 or more employees. So here you see that the idea behind the whole code is to give the benefit and extend the benefit to the maximum number of people, and to include within its definition as many people as possible. If I may please request for the next slide. Yes, another aspect of the code, which is insurance. Now, what it does is, if I may just very quickly, because I think we are, do we have time, to take this thing?
Yeah.
Thank you. Thank you. I'll quickly try and finish this in 5 minutes. So when we look at this entire code, insurance is a very important component. So what it first does is, it mandates that if there is a liability, there is a duty of an employer to actually make sure that the employees are insured, and it would apply to every establishment with 10 or more employees. So and the whole concept that whether you are the nature of your job is life-threatening or it is hazardous or not, that is not applicable anymore. You will have to insure them irrespective of the nature of your occupation. Then going further from there, it recognizes now one problem that one would face is that across industries there were some benefits which were recognized, there were some benefits which were not recognized. So for example, pregnancy related, leaves or medical treatment, they would differ from employer to employer. Now, what it has done is that it has made it mandatory for an employer to recognize certain heads. So, for example, the funeral expenses is something which is now recognized. Then the other thing that it has done is that, in case, there is it has also, come up with, provided with an entire mechanism that says that puts a liability on an employer to pay its contribution. So, for example, the primary responsibility for payment of contribution on the employer, recovery is provided for. So, for example, if the liability is on an employer, and if the employer defaults there, the employer may have to face recovery. It could be recovered from the employer. Then the other thing that it does is that in case of an accident during work, the presumption will go in favor. So usually the law is this, that the person who says that this has happened, the liability, the onus lies on the person to prove it. Now, in certain cases, in certain laws, looking at the social conditioning, the law makes an exception, which says that maybe, the onus in general cases would lie there, but in these circumstances, we'll presume that what the person is saying is right. So, for example, in a normal circumstances, if an employee meets with an accident, he will have to show and prove that he will have to actually prove it in the court that this is because of my arising out of my employment. And therefore, this accident or this sickness or this thing that I have contracted during the course of my employment, I am liable to be compensated for that. So the law, there are many Supreme Court judgments also on this point, which says that any disability which has been acquired during the course of employment, that is something which warrants compensation, and the person becomes entitled to that compensation. And in many cases now, under the Disabilities Act also, they talk about that in such cases a person has to be accommodated to some other provision, so provided that applies to the employer. Now, what happens by virtue of this code is this: the presumption will be this, that yes, it is arising in the course of employment, and now the burden will be on the employer to prove that it is not in the course of employment. So this accident has not happened during the course of employment is something that now the employer will have to prove, not the other way around. So this is one. Secondly, by saying, providing, that what is it, defining that this is a gig worker, this is unorganized worker, they have, now not just brought them within the ambit of the act, but they have also empowered the government to frame schemes for their benefit. So broadly speaking, these are some of the things, that they are trying to, which are the key highlights or key takeaways that we can say from the code as of now. May I request for the next slide? Yes. So as I said, there is a broad act-based applicability. Then the impact of definition of wages will have an impact on the PF contribution and the entitlement of a person. Then again, the limitation period of 5 years for initiating and 2 years for concluding inquiry. So what it does is, whenever there is a claim or there is a dispute, they have come up with a mechanism that is trying to show that these are some of the we'll try to adhere to a strict timeline so that things are disposed of in a in a friendly manner. Then they have also provided that you could, a single return could be filed, because now that you are expected to do compliances, they are trying to do everything electronically, and hopefully in due course and time to come will be really effectively be able to implement all these things. So but these ideas are now being introduced in the workings. And then lastly, as I said, one of the major takeaways is that your basic salary should not be less than 50% of your gross salary, as a result of which a lot of other things, as I said, are going to get affected, which means your PF contribution, to give an example, is one such thing, that your PF contribution as on date is 12% of your basic salary. So if your basic salary is 500, and not 400, your PF contribution will change. So in effect, what happens is, if I have to put it in a layman's language, upon retirement, you end up taking more corpus. And while there could be criticism for of the code, one thing is for sure, that it is definitely one major step in our which is going to change the scenario of labor laws in India. If I may please request for the next slide. Yes. The other thing, as I said, is, that by recognizing gig workers and people from unorganized sector, and by making provisions to have schemes for them, by doing so, you have extended benefits like insurance, health, maternity benefit, and even so, for example, under this code, the government is expected to come up with schemes for providing crèche and other benefits, which were otherwise for the benefit of the employees. And when I say employees, it will also cover employees for the unorganized sectors also. So these are some of the things which, if implemented in long run, is really going to change the working scenario of our country. Then the other thing is, which, if I may very quickly, because I think we are running short of time, if I may just highlight, that it is the code can very easily be, divided, of course, in terms of the 9 components it seeks to cover, but also in 2 parts administratively. So while there is one part which deals extensively in defining what wages are, what the fixed term employment would mean, what's the gig worker, and there is another portion of the act which deals with this whole concept of how the government would provide for a scheme and how the scheme is going to be implemented. So there is a lot of concept of creating funds. There is a lot of concept of creating that the scheme and mechanism, and overall the code envisages a regime where these benefits, where funds could be generated so that these schemes could be implemented. If I may please request for the next slide. Yes. So with this, I think we have broadly covered most of the thing. Due to paucity of time, I was afraid we could not cover all aspects. But if there is anything, we may take up those questions now.
Thank you, Mayuri. Most of the questions prior to this webinar, you have largely covered. Just question around any anticipated challenges in implementing these new codes. I believe they are effective from 1st of April 2021, but any anticipated challenges for the organizations who have to go ahead with implementation of these new codes?
Well, see, it's a hypothetical question, because we'll know when it is implemented, and we will know in due course of time when the disputes will arise. So right now saying this is very hypothetical, but there are a couple of things that I can highlight, which in my opinion, this is my opinion, that I anticipate and things may happen. So while the concept of wage is something they have tried to define and they have tried to give a standard definition, I cannot, ignore the fact that it is something that may fluctuate on a monthly basis. Now, the moment something starts fluctuating on a monthly basis, it may become difficult again, to, say that why we have simplified it. So it would be, while maybe your intention could be very noble in, affecting the, in implementing, in saying that it is simplifying, but maybe it's not simplifying because you have excluded many categories from the definition of wages. The other problem that I do see here is that, of course, there are many, but I'm just for the time being skipping the dispute resolution problems that I foresee, and we are just trying to concentrate on, the challenges, the ambiguities that I see here. So, for example, there are these concept of it talks about that we index, and we are trying to consider the standard of living of a workman into account while fixing the floor wages. But the problem is this, that when we actually look at the definition of wages, and when you see the change that they have undertaken it, we fear that perhaps the take home salary of the employee will actually get reduced. He may may end up paying more money towards the retirement, towards the PF, towards other benefits. So the actual money that will come in his hand for use, and this is something which assumes all the more importance, because during the COVID times we know that people are in need of money in hand. So I wonder, when when we are actually going to implement it, whether we will be flooded with disputes regarding the take home salaries or not. So this is one aspect here, to say one. There are others also, but this is one aspect that I do see, that we may have a problem.
Thank you, Mayuri. I think you've largely covered my question on behalf of the audience. Once again, thank you, Mayuri. Thank you to the entire audience who have joined us. We will be organizing our next webinar to throw more light on the implications of these new codes on the content-based restructuring. So please stay tuned with us for the same. And we also will be uploading this webinar on all our social media platforms. So please do check. And if there are any questions, please feel free to ask those questions on our social media page as well. We'll direct them to Mayuri, and we'll make sure that we are answering, to our best capacity. So thank you and goodbye to everyone.
Thank you.
Thank you.